Policy Committee of a whole for the date of November 1st, 2023. All right, we're going to start with, can y'all hear everything?
Yes, it's working.
He heard it. We're here at Independence High School, and everything's set up a little bit differently, but if y'all want to talk in the mic, he's got two set up. Just don't throw it down because it's going to blow his ears off. All right. Number 1, consider approval to delete policy DIBA. Oh, roll call, Miss Cindy. I'm sorry.
Mr. Mingus. Present. Mr. Moore. Here. Mr. Westmoreland. Mr. Duncan. Here. Ms. Richards. Mr. Total. Here. Mr. Piazza. Here. Mr. Abrams.
Here.
Mr. Anthony.
Here.
All right. Consider approval to delete policy DIBA. Mr. Jinko?
Yes, ma'am.
I guess you're going to be Mr. McNeely?
I'm doing my best impersonation of Mr. McNeely tonight.
Okay.
For the first few.
It's like echoing and when I talk. Okay. Still a little bit echoey. Testing 1 2 3. Testing 1 2 3. 1 2 3. That's a little bit better.
Just blame it on the building.
All right, Mr. Ron.
Good evening, everyone. The elimination of policy DIBA is Forethought's recommendation for the American Recovery and Reinvestment reporting requirement for which time has expired. So that's
You
their
turn music
recommendation.
on now. Testing, testing, testing. Okay. Yeah, he hears me fine, so don't worry about it.
Motion to adopt.
We have a motion. Do we have a second?
Second.
Who was at the second?
Mr. Duncan,
Okay.
second.
Roll call. Call to vote, Miss Cindy. I don't see her, so I'm like lost. I know. I'm looking for her. She's not there. Yes. Yes. Yes, go ahead, Mr.
Yeah,
Moore.
Ron, you said that this policy was expired.
Yes, sir.
Yes, I see it was done in 2009.
Yes.
When did it expire?
Mr. Moore, to be honest, I do not know. I know the funds that have been expended already. So my humble guess is that the COVID funds have probably taken the place of these funds. But as far as the date of when it expired, I do not know. But I can find out and let you know.
All right, that's the only question I had. I heard you say that, so it just stood up a little bit of a curiosity for me as to what date, if we were past the due date of it expiring, or if we were just nearing it. So I'm good.
Okay, you want to vote yea or nay, Mr. Moore? You want to vote nay, yea or nay? Okay, Miss Cindy. Everybody voted.
Yes.
Okay, we're going to move on to revisions. Consider approval of the revision policy DC annual operating budget.
Yes, ma'am. The one addition to the policy is that no later than September 30th of each year, the school board shall post the most recent budget and general summary on its website.
Second.
Motion by Mr. Toller, second by Mr. Piazza. Any questions? Call for a vote, Ms. Cindy?
Dominguez?
Yes.
Mr. Duncan? Yes. Mr. Toler?
Yes.
Ms. Abrams?
Yes.
Mr. Moore? Yes. Mr. Westmoreland?
Yes.
Mr. Piazza?
Yes.
Motion passes unanimously.
Okay. Consider approval of revision to policy DID. Mr. Ron?
Yes, ma'am. The one addition is that within 30 days of notice of the approval and acceptance by the legislative auditor each year, the school board shall post the most recent annual independent audit on its website.
Make a
Have-
motion to accept.
Motion by Ms. Dominguez. Second by Mr. Anthony. Any questions? Call for a vote, Ms. Cindy?
Dominguez?
Yes.
Mr. Duncan? Yes. Mr. Toler?
Yes.
Ms. Abrams?
Yes.
Mr. Moore? Yes. Mr. Westmoreland?
Yes.
Mr. Piazza?
Yes.
Mr. Anthony?
Yes.
Motion passes unanimously.
C, consider approval of revisions to policy BCBK. Mr. Ron?
There was an addition of reasons that the board could go into executive session that include discussing concerning cybersecurity plans, financial security procedures, and assessment and implementation of such plans or procedures.
Motion by Mr. Tom, second by Mr. Piazza. Any questions? Call for a vote, Ms. Cindy?
Dominguez?
Yes.
Mr. Duncan? Yes. Mr. Toler?
Yes.
Ms. Abrams?
Yes.
Mr. Moore? Yes. Mr. Westmoreland?
Yes.
Mr. Piazza?
Yes.
Mr. Anthony?
Yes.
Motion passes unanimously.
All right. D, consider approval of revision of policy EBBC. Mr. Jinko?
Yes, ma'am. The Emergency Crisis Plan Act 334 made some changes to some statutory language applying to the school crisis and response plan, and also added some new definitions such as district threat assessment team, emergency preparedness, and a recovery point of contact is language that has been added to our already existing plan.
Will make a motion? Mr. Anthony made a motion. A second?
I'll second.
Second by Ms. Dominguez. Any questions?
Yes, question. We've added a lot of, really, oh, sorry. We've added a lot of really rules, that have to be done. And I'm wondering, did all of this come from a new state law, or was this forethought suggestions? Because, I'm looking at the very last page, and it says, each principal shall keep a copy of the approved plan in the office, which is standard, and we should provide a following individuals, each department to whom it's responsible. That's fine. The office is fine. But why do we have to give it to the president of the school board, the superintendent, the chief of police, which those three things are good? Why the Louisiana Department of Education and the Center for Safe Schools with the governor's office for every principal in every school in the whole entire state?
It's statutory, and my guess is that they want to verify that we have done the things that's in the statute in case there's an issue.
So within the first 30 days of each school year, we'll have to conduct the drill based on this plan and address or adjust the plan, and then send it to, for every school in our parish, and every school in every parish in the whole state has to get that to the governor's office and to the education department?
If that's the language in there, then yes, ma'am.
Mr. Ron,
Sir?
Didn't they approve some money to go with this if you comply with this plan or something?
I know there was, at the beginning of this, there was, but I have not seen or read anything where they've given us an amount to associate with this particular process.
Go ahead, Joey.
Mr. Ron, I just got a quick question. I'm reading the first paragraph where it says, "District Threat Assessment Team shall be established by the school board. Team shall include superintendent, the principal of the school, and a person responsible over school facilities, and a mental health professional employed by the school system." Are we going to have to add a new staff member for the mental health part? Are we going to try to use one of our counselors?
No, sir, we have counselors, or we have the individual that's over the counselors, Ms. Gonzalez.
Just want to make sure.
And that district threat assessment team will be the group that will drive the formation of the plans and the changing and so forth.
Okay.
Any other questions? Call to vote, Ms. Cindy.
Yes.
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 Yes. Yes.
Moving on to E, consider approval of the revision to policy EBCB, video monitoring of school board property. Mr. Jinko?
Yes, ma'am. The policy, as it was video monitoring of school board property. Now it's video/audio monitoring of school board property. So they've added audio into every spot, and they've added some language in the green there. The new parts of the policy just talking about protecting precautions to ensure that student privacy is followed and protected.
Have a motion?
I'll make the motion.
Motion by Mr. Anthony, second.
I'll second. I have a question.
Second by Mr. Toller. Question?
Yeah, in the paragraph on page 2 where it says, "And upon request, a bona fide news gathering organization covering an incident." So how are they going to request this video or audio footage, and how do we determine what's bona fide? If we just don't like them, or we do like them?
Now, I would imagine they would acquire the footage, kind of a public records request.
Any other questions?
And then we would contact our attorney and say, is this a public records, yes or no? Then we'd give them whatever they needed by law.
I could just see that being something that they would start doing very often, especially with fights or anything else. We'd like to get a copy of the tape.
Yes, sir. And we've had requests for that, and we redact as best we can faces of individuals that are not their students.
Okay.
Any other questions?
Yes, Joey and I were discussing the highlighted part on the top of the second page, where the school board should take precautions to ensure the student's safety shall be protected, viewing of the recordings, et cetera. And then the next paragraph says the superintendent shall set and maintain procedures regarding the request to review recordings by parents, legal guardians, or bona fide news gathering organizations. So to spin off on what Tom said, should that not be a policy written by the board or a policy adopted by the board, not just the superintendent?
To
set procedures for how we're going to do that. How the school system is going to have procedures regarding the request to review recordings. Would the board not have to make a policy or have some input in how that would be done?
we have procedures set, but if the board wishes to develop a policy, Student Services would be more than willing to assist you in the development of this policy.
So, just to kind of echo that, I agree kind of on the point of what Tom said, Mr. Toller said a few minutes ago. That's going to be your biggest argument with a parent is asking for this phone. I think that we have to do due diligence to make sure we have a correct policy in place. So if we need to adjust what we have currently or we need to make a whole new one, I would like us to take a look at that. Since we're having to revamp this policy, I think we need to look at the other one too, just to make sure that it's on par with what we're addressing here.
Ms. Dilly?
I was just going to add that we currently, right, Mr. Jinko, have a policy when a parent, they occasionally will request video of something at school. And there is a procedure that we have in place. We're
Correct.
happy to bring that procedure. We can actually, share it with our attorneys to make sure that it's within the policy and then bring it for the board to look at and to approve. But we currently have a procedure in place, and we have to make sure that other students are not identifiable in the video and things like that to protect their, privacy.
Any other questions? Call to vote, Ms. Cindy.
Yes.
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 Moving on to F, consider approval of the revision to policy ED, student transportation management.
Yes, ma'am. This is if the school system was ever wanted to purchase that multifunction school activity bus. The best way I can't describe it, I'm going to show you, I call it the shuttle bus. If we ever wanted to purchase those, they can be used to transport kids for activities like the football games and different things. They cannot be used for picking up students and bringing them to school on a route. So that is just added in here. So if we ever choose to do that, we can run flag teams and different things like that, but they cannot be used for a route.
I'll make a motion to accept.
Second.
Motion by Mr. Mingus, second by Mr. Piazza. Any questions? Call for a vote, Ms. Cindy.
Yes.
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 Moving on to G, consider approval, a revision to policy IDFAA, drug testing of athletes. Mr.
Yes,
Jinko?
ma'am. At the beginning of the school year, we found out that we had a little glitch in our safeguards, so we took some time, developed some safeguards, and we have them outlined for you here in green. Just things that we think need to be done to make sure that parents are notified that their child's going to be drug tested, gives the opportunity for the child to tell us, yes, I'm playing the sport, not playing the sport, etc.
I'll make a motion
Miss-
to accept.
Mr. Jinko?
Yes, ma'am.
We did have our attorneys look over these and give approval before we bring them to the board.
Correct,
right?
yes,
Yeah,
ma'am.
thank you.
They assisted us in developing them.
All right, we have a motion by Mr. Mingus, second by Mr. Piazza. Any questions?
Yeah, just one. So the one that says the parish athletic coordinator designee will contact the parent or guardian of the student athlete prior to the student being tested. So does that mean prior tonight, I'm going to call the kid in the morning?
No, ma'am. That means when they go to the school in the morning and they come pull Ron out of class, that we're contacted mom, dad, guardian right then and there to say, hey, just to let you know, Ron's being drug tested. That not the night before. or
Yeah, okay. That's what I
Before
was-
it happens that morning. Yes, ma'am.
All right, any other questions? Call for a vote, Ms. Cindy.
Yes.
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 Moving on to H, consider approval of revision to policy GBRIB, sick leave. Dr. Fursell?
I yield the microphone to Dr. Fusell.
I told you to keep going. I think you should keep going, but thank you. And both of these, actually GBRIB and GBRIC, there were two acts passed in the last legislative session, Act 133 and Act 296, so we're updating our terminology. Act 296 is where
Anywhere we said physician, we now say clinician because that is physical, a physician or a PA, a physician's assistant. As most of you know, you can't always get in with a physician today. You might see a physician's assistant or an advanced practice registered nurse. So in both of those, actually in policy GBRIB, that's where we changed physician to clinician. And I ask for you to approve that. In Act 133, where it says teacher, it now says employee, because it was, you had to have a certification, you had to be a certified employee, and Act 133 said just employee. So anywhere in our policy that it said teacher, we've now changed that to employee for those two policies.
A motion to adopt.
All right, so that is a motion to adopt H by Mr. Piazza and second by Mr. Westmoreland. Any questions?
Okay, so Mr. Dell, so it scratches out nurse practitioner, but is a nurse practitioner considered an advanced practice registered nurse?
The physician's assistant, so it falls under clinician.
Okay, because there was such a thing as a physician's assistant and like Lexi is a nurse practitioner.
Yeah, it's there, that goes together.
So it's all
Yeah.
clinician, okay. So in this policy, it's pretty basic. The next policy, we did not, just to clarify, we did not have maternity leave on the, anybody that drove a bus or any other people besides teachers. So now we're adding
It had
anybody.
it had to do with the days. It was over 10 days, but yes, ma'am. That now it's just employee. It doesn't matter if you're certified or not.
They drive a bus or whatever, okay.
Right.
So that's what the second policy is?
Policy, yes, ma'am.
Okay.
Yes, ma'am.
Want to let people be aware of that.
Yes, ma'am.
All right. Call for a vote, Ms. Cindy?
Yes.
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 All right, so we're going to move on to consider approval of revision policy GBRIC, which is the maternity and adoptive leave. So we
Move to adopt. Second.
move to adopt by Mr. Westmoreland, second by Mr. Piazza. Any questions on that one? Call for a vote, Ms. Cindy.
Yes.
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 Thank you all.
All right. We're going to move on to board member recommendations. A is consider approval of the revision to policy JCDB, student dress code, Mr. Trent Anthony.
All righty, thank you. Is this on?
Yes,
Yeah,
sir.
you can hear me well. Okay, so what we have, I started out with a different policy and I simplified it way down. I did a lot of research from other parishes throughout the state and found that we are the only parish left besides Livingston that has a to-the-knee skirt policy. And Livingston even grants, I think, 4 inches above the knee on shorts and skirts. So that being said, I'm asking that we follow suit with the remainder of Louisiana and come up with a different policy that allows skirts, skirts, and shorts to be 3 inches above the knee. Somebody want to, we got to make a motion before we ask questions?
Yep. Who wants to make a motion on that?
I make a motion.
Okay. Motion by Mr. Anthony, a second? Second by Mr. Duncan. Any questions?
Am I allowed to take a minute to further introduce or give my reasonings behind this, or should I have done
Sure,
that before the motion?
You could go
Okay.
ahead.
Just a couple quick notes. The current policy was from the early 2000s. I think it was 2000, actually. So apparel was very different back then. 23 years later, we're a generation later. I do want to point out that I shopped for 2 current students and found that I could not adhere to our current policy. So we Both of my kids have been issued citations, and they are very, very close to the knee, but not quite all the way. I would like to add, I've talked to several administrators who have already either made their own policies with skirts and shorts or have just completely ignored our current policy. A lot of people are saying, they're using the ID card and saying, hey, if it's your kneecap, ID card, skirts, or shorts, we're good. It's about a 3-inch gap. I think the ID card is exactly 3 inches, in fact. Last but not least, talked to many, many, many other parents, many, many administrators that have basically just given up, and no one is adhering to the policy we have. It's embarrassing. I think it's embarrassing, and I think we have a policy that's outdated, and we need to correct it. And I was going to print the policies from the other 25 parishes we researched, but I just suggest you Google that, and you can check it out for yourself. We probably don't have time right this second, but we have an antiquated policy that can't be followed, and that's the reason I introduced this one.
Trent, did you ask them if they would? Did you talk to them and ask them, would they enforce the 3-inch policy?
Yes, sir. That's some teachers, I don't want to throw any names out because they're breaking our current policy, but they're saying that's the policy they've adopted. They say, let me see your ID card, and they put it down there, and if it's close, if the skirt comes down to the ID card and the ID card touches the kneecap, they're letting them go. But many of them said we have just kind of just given up altogether. We don't have a policy that can be adhered to right now.
My only concern is if the administrators are actually going to do it, are they going to say now it's 3 inches, we're going to allow 6 inches, and we're going to ignore it or not? If we make the rule of 3 inches, I would hope our employees would enforce that.
Yeah, I think they will. Again, it's like when they can't enforce it, period, right now. So if we say, look, y'all, the rule just came out, we're giving y'all the 3 inches, I think it will start to catch on. If they're short beyond that, the whole excuse of, hey, we can't find to-the-knee apparel, that won't fly anymore. You can find apparel 3 inches above the knee. That is, I have found that personally.
Call for a vote, Ms. Cindy. Oh, we got a question?
Well,
Oh,
he
he
was
said
calling
call-
for a question. I was just going to ask Mr. Jinko his opinion as the person in charge of
Yeah, we did.
discipline.
Yeah, the expert. My opinion is the board approves it. We will implement it to the best of our ability. We will remind our schools. We'll use the 3-inch if it's the ID card. We'll do the best we can to implement the policies that you implement. I can't guarantee you that it's going to be done at every school every day, but we will do the best we can to make sure that word gets out.
All right, call for a vote, Ms. Cindy. Oh, Ms. Stilley has one thing.
I think Mr. Anthony's recommendation is reasonable, and I think he's done, thank you, by the way, for the time and effort of researching that. And I do think if you have something that's unreasonable, I think it's justifiable to adjust it. So, I'm not opposed to that at all.
Anybody else? All right, Ms. Cindy, call for a vote. Yes. No, it didn't. It didn't pass unanimously. Joey voted no. Yes. All right, we're moving to B, discuss policy BCBL, invocation before school board meetings. Mr. Piazza.
Yes, so as I said at the last board meeting, referred this to policy. We had a prayer policy that was in place. It was a little old and outdated. We had, as most of you know, a lawsuit a long time ago that ended up going to the Supreme Court. Supreme Court ruled in our favor. Since then, we haven't really addressed our prayer policy since it was created. I reached out to our legal team with Ms. Indigo. She looked at our current policy and what currently is available in our state, and with that Supreme Court ruling. With that being said, she made some changes to our policy to now be enacted with the current laws and our standing with the Supreme Court ruling. So now we can have prayer at every meeting as long as it is an open prayer. So we won't have to send out the sheet to all of our local pastors and stuff. Anyone can say a prayer as long as it is open, and that way it's fair for everyone that attends. So I'm asking for us to try to adopt that tonight.
I have a question. When
Yes.
you say open, what is that exactly do you mean by that?
Meaning we will have to, so what we're also getting Ms. Indigo to do is when we, have that little thing we have showing at the screen for the public input and stuff like that, we will add a thing in there to where anyone can come up and say the prayer. So we can't sit here and go, okay, well, he's always going to say the prayer and it's
Gotcha.
always going to be this. It has to be open to the public. Open invitation to anyone.
Okay, so
to
if no
come say.
one steps up to the podium, can one of us
Yes,
do
we
that?
can,
Okay.
as long as we step down,
Okay.
as long as it's not as our capacity as a board member. So we would have to get from behind the board and say that we're doing it on our own free will here,
Gotcha.
not as board members.
All right.
So I make a motion to adopt.
Motion by Mr. Piazza, second by Mr. Toller. Any other questions?
Well, so our only thing is we still can't do it in the meeting. It has to be before the meeting. At the beginning, before the meeting starts,
Before we call
the
the-
gavel, the same as it's always been, correct? Want to justify, Mayor, make sure we got that.
Yes.
All right, Mr. Duncan?
So Joey, in the policy though, we're still saying that we are having the secretary of the board compile and maintain a database of congregation lists, and we're still having the secretary send out the letter to all of the religious leaders. Was that your intention, or was it your intention to just go to an open prayer policy?
So this was done by Ms. Indigo, what you see here, the revisions, but I do believe we can scratch that if we don't want it in there. I think that was just an extra precaution to kind of make sure that we had people trying to attend the meeting if we didn't want it just having full open.
I mean,
But I would like to scratch it if we can, yes.
Well, I know where that comes from. That comes from the settlement documents that we did the last time this issue went before the court. But as you said, since we did our settlement, the Supreme Court has kind of changed its thinking on all of this. I guess we can just move it forward, and maybe before we do final adoption on Tuesday, maybe ask Indigo to come and just walk us through her thinking on why she proposed what she proposed.
Yep.
But I would like to hear from her as far as what her research was, and just make sure we all understand, why she's proposing what she's proposing.
Mr. Toller?
Yeah, just one thing to add to that. Whether we leave that in or not, Brett, correct me if I'm wrong, but just adds another layer of protection for us trying to include more people. And I think the intent, from what Indigo was told us earlier, as long as we're not excluding anyone, in other words, open invitation to anyone to pray, and we have to be aware that that prayer may not be the same faith that we are, that we have to give that open invitation to pray. And by sending letters out, I think we're just helping the cause as far as letting people know. So whether we strike that or not, I don't think it's going to make any difference, but it may be good to leave it in.
Yeah, and I'm really, I guess so. I'm just still a little confused by, let's say we have this open process, but we've received notice of multiple people that want to pray before one of our meetings. Do we have to offer it to multiple people who want to pray? And if not, how do we go through the process of picking which one of the multiple options gets to pray that night? Yep, me too.
Well,
Sure.
Ms. President.
Go ahead.
So I was just going to, Mr. Jenko's been here through this whole process, so I want to get a little clarification from him, if he don't mind. I'm with you, with Brett. We did this a long time ago, but according to the document, Ms. Jenkins is supposed to have the list, and then she gives us the name of that night. I'm thinking our intent could be, if no one shows up, or if she doesn't have anybody assigned for that day, if there's someone available in the audience, but other days, she may have people already assigned, and those will be the assigned people.
I know the process, like Mr. Duncan said, was with the settlement. And that may be a question that we can give to Ms. Indigo today, tomorrow, so she can come Tuesday to answer questions. If we send out the letter, no one responds, where do we go from there? If there's a volunteer from the audience, or if a board member wants to step down and do that. I definitely would think that's something she needs to respond with.
Can I add something?
Sure.
Yes. So I'd like to ask Ms. Jenkins, you send the letters out now, and there's many times when we don't have anyone that takes us up on the offer to come and pray. We've had about 5 during the, you send out, okay. I'm going to hand this to her so she can explain what she does.
I send out about 300 letters to Tangipahoa Parish churches, and consistently about 5 pastors respond. Yes, whoever responds first, well, they get their choice of what day. I send them a list of our scheduled board meetings. They pick the day that they're available. They can pray up to 3 times per year, according to the old policy. And then whatever day is open, the next person gets. And then that's it. Yes, there have been many nights where we haven't had anyone, and that would be the opportunity to open it up to someone.
And just to comment on Brett's point about who would get first dibs to pray, I don't believe that we can be exclusive under the new bylaws on, so let's say a pastor says he wants to pray on the next meeting. If somebody steps forward, I don't believe that we can deny them their right to pray just as much as we can get them according to the new guidelines of open prayer. Again, that's a question for Ms. Indigo. I agree. I think we need her to come that Tuesday night just to make sure before we do final adoption.
All right. Any other questions? Call for a vote, Ms. Cindy.
Yes.
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 All right, C, consider approval of revisions to the Student Code of Conduct Blueprint for Student Incident Response, Mr. Anthony. You're just
thank you.
all controversial tonight.
I'm trying not to be, but yeah, I'll briefly explain the reasoning behind this. And as you know, we all adopted this code of conduct in August, I believe it was, and I really like many things about it, including the discipline review committee. I think that's a great step in the right direction. One thing that we found that even our students were bringing to the attention of administrators and teachers is that in level 3, they were given oftentimes 2 and 3 opportunities to participate in a fight. That was the way the administration was looking at this rule and thinking it should be applied. The fights got out of control, particularly on the south end, and even more in particular at Ponchatoula High School. There were 37 fights in the first 32 days. And when we met with administration there and we advised them that we thought it was best to move all violent altercations to a level 4 and send these students to the DRC, the fights stopped. We've had 5 fights now in 5 weeks. So the message got sent out to the parents that fighting in disrespect to authority or staff members will no longer be tolerated. And after the message got sent, the fights kind of ceased. So if you look at the policy itself, let me pull it up because I don't have it memorized, believe it or not. Thank you. So what we've left in level 3 is an opportunity for a student that participates in a fight due to provocation or self-defense. That student can remain in level 3, and the discipline for that could be as little as a detention or no discipline at all. I'm sure we can make a case for that as well, even though the consequences are kind of spelled out. It'll be some principal discretion there. But all the other fights, for example, instigating a fight, participating in a group fight, instigating or participating in any conduct or habits injurious to others, go to level 4. So I believe the message needs to be that we cannot tolerate aggressive behavior and students that initiate fights and students that participate in group fights. And I think we need to get that message out to the community. And the only other change on there is in the consequences. It said level 4 consequences can be the same as level 3 examples, but may also include consideration of longer-term exclusionary discipline, and I think that word should be shall include consideration of longer-term exclusionary discipline. And then, if our DRC thinks that the principal overstepped, we do have that committee in place to say, hold up, we think that you overreached here, and we want that child to be given another opportunity.
All right, a motion?
I'll make a motion.
Motion by Mr. Anthony, second by Mr. Piazza. Any questions, anybody? Go ahead, Joey.
It's more of a comment than anything. I want to echo what Trent has said here. After speaking with a lot of members of staff at Ponchatoula High School and Hammond, fighting has become an issue on our campus because students feel safer fighting on campus than they do outside of our campus. They know that the fight's probably going to get broken up. They're not going to have a weapon usually if they get in a fight on campus. And it has become an issue for our staff, who are mostly women on our campuses, and it becomes a big issue. I think we have to set the standard and we have to set a tone. And that was one of my main arguments when we adopted the Student Code of Conduct the first time, this blueprint. I think these revisions are good because I think the tribunal is a wonderful addition, and I think it does a good job as of right now. So I think they could catch the discrepancies that we bring. So if you have a student who is defending himself and is not one that's a habitual breaker of the rule, they will get a lesser thing according to the tribunal. So I think we have the safety net in place to even move this to a level 4. Well, we didn't have that last time with the zero tolerance policy.
Mr. Duncan?
Questions from Mr. Ron. Mr. Ron, if I can get so, obviously I've been opposed to this policy from the beginning. I'm still opposed to it. I still think it's a deeply flawed document and direction. This certainly moves it in a better direction. But with this change to the 4 and the fact that we're now shall consider or it shall be referred to the Discipline Review Committee, one of the issues I have with the Discipline Review Committee is there's not really any direction in this document still about what authorizes this Discipline Review Committee to overrule a principal's recommendation. Like what is, in the legal world, we would call it a burden. What's the burden or the what do we call it? The level of review. How do we approach that? So do they just have full discretion as a Discipline Review Committee for any reason to say, hey, no, I don't like what the principal did here, so we're going to kick it back? Is there any discussion on that?
Oh, yes, sir. The Discipline Review Committee, it's when the individual walks in, the student and the school walks in together, and the school gets their time. They give exactly what's going on, why or what incident or incidences brought that particular student to there. They go through the grades of the student. They go through the attendance of the student. They read statements from the individual's teachers about how he or she's doing in the classroom, etc. The student and the parent has their 10 to 15 minutes to give their type of rebuttal, so to speak, and their version of what happened. Then the DRC asks questions, and then the DRC just reviews all information and then makes a determination they agree with the school's recommendation or they will modify it some kind of way.
But here's where I'm at, Ron, and I appreciate the process. What I'm specifically talking about is, let's say we have a situation where, because it seems like this is what can happen. The principal has done everything according to this document. They've followed all the procedures, and we're going to throw out whether there's a special education situation.
Correct.
So we're just going to say that didn't happen. but they did their investigation. There is a clear factual finding that this kid instigated a fight, right? That's been determined. We in our policy, we said that that's a level 4. They ought to be referred to alternative placement, right? And then the principal has said, it's my recommendation that that happen. According to the way I read this, a discipline review committee can just say, I don't like that. This kid seems like a nice enough kid. We're going to send him back, right? They apparently have that discretion to do that according to this document.
If that was to happen in that instance, it would not be because they liked the kid, didn't like the school. There would have to be some factor.
Well, but so how is that determined? Because here's what I'm concerned about is again, there's no direction in here that says that discipline review committee that meets on the first week of November could have one scenario that's almost exactly the same, but then the discipline review committee that meets on the third week of the review committee could have almost the same exact thing and come to a completely different conclusion. And we don't have anything in here that could really justify that other than, well, that's just what the discipline review committee did that day.
And to your point, that scenario could happen. I'm not going to stand up here and say it could not happen. But if the committees were reviewing all information and doing the inquiry, reviewing and asking the questions, the decision that the discipline review committee makes should not be one group says this, the other group says that. They should be somewhat normed together. So, and I can verify that and check that to see how various instances, unfortunately we've had too many of them so far, what the results are of the various DRC committees.
And so I guess then, what would be the challenge or the reason why we shouldn't put some guardrails in to this policy that says something along the lines of, absent a special education scenario, if there is a factual finding that a student instigated a fight or whatever, if X happens, we can come up with the list of they either instigated a fight or they caused a serious injury, and the investigation was proper, they're going to go to the alternative campus. I mean, the review committee can review that principal followed all of their steps, that the proper investigation was done, that we didn't violate due process, we considered their special education needs, but why do we need to give the discipline review committee carte blanche that just, this review committee one day says yes, the other one says no? I mean, why do we need to do that?
Well, having sat on the committee, the things that I know that we have done, it's yes, you're looking at that student X got into a fight, but then you start digging into why, the who, the what, the when, and the where, and I'm going to say at least 90% of our fights are due to community issues. Now, that does not excuse them. I assure you, that does not excuse them, but there are more things here than what meets the eye. And when we find those things out, not all students are sent back to the school. Unfortunately, we have a large percentage of them that are going to the alternative school, but the key with the DRC is when they are sent back to the school or the alternative school, there is a plan to try to make sure that issue does not happen again. I think that's the one good thing that the DRC does have, is that it is a wide variety of individuals that has a very nice tool belt of things that it can do for that child to have the consequences and make sure that event does not happen again.
And look, I like doing the individualized plans, I like doing all that, but at some point, it seems to me that there ought to be a clear message that if you do X, then you have proven that you are not appropriate to be in a traditional school environment, disrupting the school environment, the educational environment for the rest of the students there. And if our message is, well, if you do X, that's what we maybe should happen, but, that to me is where we're causing problems.
But when the student does X and we send them to the alternative school, he or she is going to have an opportunity to go back to the school. So we've got to make sure when they are sent there that they have the tools.
Absolutely, all for all of that, right? I'm all for all of that. Yeah. And I think our alternative program needs to be more robust. It needs to be more child-centered. I'm not opposed to any of that. What I'm opposed to is the wishy-washiness, the lack of a real definition on what this process really is, and the fact that it oftentimes will lead to different results for different students, even though they did the same exact thing. And then also the fact that our schools have been unsafe. The traditional school environments have been unsafe as a result of us moving in this direction. And I want to make sure that we're addressing it.
We appreciate that, and I assure you that the role of the DRC is not to make it unsafe or to overturn the principles. It's when the schools make the recommendation, if their recommendation is overturned, there was something in that investigation that was not done or not done properly, or some other information that came up after they did their inquiry that allowed for the DRC to make that decision.
I guess
And
you need to say
I-
something like, take for instance, we're in a courtroom, and you have a jury that you picked. They listen to this case, okay, it gets thrown out, or it's a hung jury, and you get another jury in there, and they do something totally different. It's the same. I guess it's the same scenario. You're getting 5 people's opinion on this case, and it might be this 5 people's opinion has totally different on the same identical case. But I mean, they have to be given the right tools to know what kind of decision they come to. I guess that's where the attorney's job is, to make those jurors understand that we need to make our people doing this process understand this is the rules that they need to follow. So I guess I'm trying to compare it to something like that.
Well, the judge actually hands down the rulings.
Well, and yeah, and I like where you're going, and I think you and I are thinking the same way, Robin. The difference, though, is that in criminal court, right, if a jury makes a factual finding that X occurred, that Billy did this, and he met the elements of the crime, then the statute then goes on and makes very clear that there may be a range of consequences, but there's a minimum range and a maximum range.
Right.
And we don't have that. What we have is this discipline review panel that's almost more like an appellate court, but that has full discretion to do anything, right? So in the legal sense, when we have an appellate court, what we would do is we put parameters even on what the appellate court can do, and depending on certain circumstances. They have to make a finding, maybe that the judge, the fact finder, abused their discretion, or they made a legal error, or they did something, right? None of those things exist in what we're currently doing. And that's part of what causes me some concern, is that there just needs to be more definition. And again, it goes back to part of it's due process, but the other part is that these students need to know what the consequences for behavior is going to be. And that was where the code process, I think, happened, and more progressive disciplinary policies are helpful, is that we can go to Billy and say, if you do X, this is the likely outcome of what will happen to you. None of that exists right now, and I think that's part of what's causing the problem.
Can I make a comment, too? I had a question for Mr. Jenko. I remember we had a conversation a while back, and I know I echoed what Brett kind of said from the beginning of this, but I remember having the conversation with you, and I think you fixed it since then. I think this is going to help a little bit to put a little bit to ease. If the DRC overturns what the principal and them have suggested from the findings that they found, they can appeal just as much as a parent can, correct?
That was discussed. That has not been put into policy. There was one of the schools that we visited earlier in the process had brought that up. So, but that is not the process as we stand here today.
Because, like I said, I think that, and then I'm going to say this then, since we're now on record, if a parent can appeal what the DRC issues as a punishment since the administration or the principals and them have done their due diligence in collecting the evidence and all that, I feel like they should get the right to come back and appeal just as much as the parent should. I mean, that should be equal across the board. If a principal says, hey, we've listed that Billy has been in trouble since the day he got here, and I've got 6 referrals, but like Brett said, we got the wrong DRC that day, we should be able to appeal to the administration.
I understand the theory, but I disagree with the wrong DRC. I'd love y'all to come sit in there and see what goes on. It's not 3 people that flip a coin and say, oh, Ron's going back. That's not the way it goes. You know, it is very, to put it in the vernacular, you have the prosecutor, which is the school, you have the defense, which is the parent and the child, and then the DRC is the judge. And again, I don't know if that's a proper way to describe it, but that's kind of what it is. It reviews all the paperwork to make sure that the I's were dotted and the T's were crossed. Okay? So it's something that, do we have issues that we need to address? Most certainly. We said it from the beginning that it is better today than it was in August, but it's not as good as it's going to be at the end of November. It's not as good as it's going to be next year at this time, because every DRC allows for professional development for the school that goes back to say, all right, we got to do this a little better. For the committee members, now that we have a few administrators on there, they're going back to their school to say, okay, I was on the committee and I did this. Now we've got to make sure we clean this up. Okay? So it's, you know, we do have issues that we need to address in the community with discipline and so forth. So we need everybody's help. We need everybody's help to make sure that our kids stay in school and get the education that they deserve. Parents, pastors, etc. We need your help.
Well, may I say something, please? Listen, for everyone who has not sat through one of these tribunals, before you start passing judgment and making decisions about whether or not it's effective, you need to go and be a witness to one of these tribunals. It is not a bunch of, these are our employees. These are our professional employees who are sitting in on that tribunal. You know, I mean, either we have faith that they are able to review the evidence that is placed before them, or we don't. I have seen this make a difference not only in the child who is before the tribunal. I've seen it make a difference in the attitude of the parents. I've seen it make a difference and change the order of conduct of the tribunal. The tribunal is not perfect. Neither are our principals who are placing these students up for placement at the alternative school. What we're doing right now is we're practicing something that is fair, and it is going to make a change because we're changing the hearts and the idea of the families in the community that the school board does have the capability of being fair. I have not seen a parent leave, except for the one. And I was not there for that one, so I can't attest to it. But for the parents that I have seen, of all of the tribunals that we have had, how many times have we had a parent do a appeal? How many appeals have we had?
One.
So that in itself tells me that there is a certain level of success. They are having a level of success. And with every parent whose mind we change, with every parent who we make more aware of the things that are going on in the school with their children, then we are getting that message out to the community.
All right. Mr.
Just
Trent?
real quick, before we delve too far down the mysterious DRC rabbit hole, let's go back to what this policy states. And the policy states that instigating a fight, participating in a group fight, or instigating and participating in any conduct or habit injurious to others ought to be a level 4. And I'm not sure how anybody can disagree with that, because what's going on right now is absolutely 100% not working. And the little test pilot run we did at Ponchatoula High School absolutely 100% did work. So whether or not those people are going to the DRC and finding success, I don't really care. I know when the message went out that we will not tolerate fights on our campus, and it went out via email and Facebook, and every parent got the message, the fights ceased. So I think that needs to be our goal. The south end of the parish is out of control. So I want the DRC to be great. I absolutely do. But that's something we have to look into later. But I think temporarily, fighting needs to be a level 4 offense, especially those that are fights of violence and when people instigate a fight.
Mr. Duncan?
Look, and as I said, I support these changes. I appreciate you, Trent, bringing them. And again, I support having this discipline review committee in theory, and I hope that we can evolve it to being something good. I still think that we have a lot of work to do. All I'm asking, I guess, is that we continue to consider ways that we can make this better, possibly to put those guardrails in, give them more direction on what the standard of review is when it comes to them, what they're allowed to do, when they're allowed to overturn an administrator, when they're not allowed. Those are the things that I think are a problem right now. I'm glad that things got better in Ponchatoula. I can tell you at Hammond, we've had 6 fights this week. All right, it's not better. I have teachers that are completely fed up and ready to quit because they're tired of dealing with disrespectful students that create problems in their class, in those buildings, time after time after time, and they get to just come right back and do it again. So the Discipline Review Committee is not fixing those things. This shift in the way that we're dealing with discipline is not fixing those things. We have got to come up with a better way to do this. Again, I'm all for having due process. I'm all for having, finding ways to help kids and coming up with individualized plans for them. I still think that our alternative school is inadequate and is not addressing the needs of those kids. We need to do better there, all right? But our frontline priority has to make sure that the 95% of the kids that show up wanting a proper education have a safe place to do that, and that our teachers feel like they can do it safely and properly without having to worry about, having to deal with just the same issues over and over and having to feel unsafe. And that's all I'm asking for. So,
All right, Tom?
Yeah, 2 quick points. It is kind of ironic, and I do support due process. It is kind of ironic that the one appeal that we did here, we were chastised because we supported the Discipline Review Committee. So keep in mind, if we're going to sit here and talk about how well they're doing, then let's not get on to the board whenever the board passes a vote where we support that committee. But then secondly, and we don't have these numbers tonight, I'm sure, but I still would like to go back to the people that are videoing these fights, because there's a huge part of this. I don't know what the stats are as far as how many students have been punished for video, for the videography part of taping these and spreading these on social media, but I'm still getting videos sent to me from parents, and these videos are starting before the fight. That is a huge issue that we as a school system, we have got to stop somehow or another. These phones should be a privilege in our school. And when someone breaks our policy with their phone, they should lose that phone for the rest of the year. Absolutely no more phone. But anyway, subject for a different day. But I would like to know the numbers on that.
One more quick one. I just wanted to point out too, when I talk about alternative placement, I don't necessarily mean task. We have homebound opportunities. We have at Ponchatoula High School. We have the Swamp. I think we're developing other things like that at other schools. I think virtual and homebound are kind of one and the same, if I'm not mistaken, right? Ms. Seeley, is that correct? Okay. So we have multiple ways that sometimes these kids aren't bad kids. Sometimes they just don't necessarily need to be on campus right away. If they, for example, beat somebody up really bad, that the victim doesn't want to see that kid in the next 9 weeks, So anyway, any way we can still get this child a good education, I'm 100% in favor for. And anyways, I just wanted to point that out really quick. It doesn't necessarily mean task.
One more?
So my overall consensus of this scenario is that the things that we've done in the past have not worked. All right, it is time. Well, I don't think we've given the Discipline Review Committee I don't think we've given their efforts enough time to actually judge whether or not it's working. You know, so we had 6 more fights. A lot of times the cure for a disease, the initial effect is worse than the disease itself. I don't think we've given this process enough time to actually determine whether or not it has been effective or not. You know, I know that it has been something that, you know, some of us don't, has objected to from the beginning. And all I'm asking is that, you know, you be a little more open-minded and let us see where this is going. I believe it's being effective. From my point of view, from my observation, we are having good results. Ron, I would ask, how many repeats are we having?
I've only know 3 kids that have come back twice to the DRC. I would like to piggyback off of what Mr. Duncan mentioned, that as the person that's over student services, I will pledge to you and everyone sitting at that our job is to make sure that the 95% of the students that want to be at school are getting the education they deserve and have a safe in-school environment, and that the 5% get the necessary consequences for their actions. And we have been working with Hammond High to try to improve that, and we will continue. Sounds like today that they had a bad day, so we need to readdress what they've done and make some adjustments. But I commit that to you and everyone here that we're going to do the things we need to do for our schools to be safe.
All right, we had a motion and a second, so and no other questions. We're going to call for a vote, Ms. Cindy. I don't think there's any public here. Nope, no public input.
He did.
Call for a vote, Ms. Cindy.
Yes.
Yes. Mr. Moore?
Yes. Yes.
Not yet. Mm-hmm. All right, I think that is it for our policy meeting. If anybody else would like to go and look at Independence High School campus while it's still daylight, we can walk out. Meeting adjourned.